Yes.
Your Lordship, I beg to mention item number 6.
Yes.
Yes, I'm on behalf of the petitioner, Your Honor, here.
Okay.
N. Sharma, Mr. N. Sharma. I want to take adjournment in coming 17 November.
When
17 November.
on the prayer of the learned counsel for the appellant, matter stands adjourned and be listed for hearing on 17th of
17th.
December 2015.
Obliged.
One item number.
Lordship, this
Yes.
matter may be taken up after a week.
Why?
Senior counsel is out of station.
Out of station, okay. But I think respondent number one's affidavit is necessary. Chief Secretary. Department has filed that the tribal affairs and all something like that, isn't it?
Yes, my lord, but basically contention will be same, my lord.
Contention will be
Will be
same,
same.
but ultimately an formulation of a rule.
Right, my lord.
So Chief Secretary send this. Anyway, we are
Well,
adjourning
yes.
to cover it.
My lord.
I think so, because ultimately you have taken a stand that you need to reassess the situation.
Right, my lord, what exactly they are asking, as per the act, my lord, we should make a rules also. My lord, our stand basically is that when acts cover everything, rule may not require at this stage, my lord.
Okay, we'll examine anyway.
Yes.
On a prayer of the learned counsel for the petitioner, matter stands adjourned and be listed
After a week.
after 2 weeks.
Up to 2 weeks.
Yes, this matter has already been admitted.
Yes,
So we'll hear it.
it was.
Actually, I sought for hearing of the matter today.
But already admitted. I thought that this is matter stage is for admission.
It was already admitted.
Already
last Monday.
admitted. But you have come, this is a driver. You have come on how many years?
It is their allegation, my lord.
Not their allegation,
Yes.
admitted position.
There is no any record.
We'll hear it some other.
Petitioner has reverted the allegation, my lord.
That's correct, but admittedly, the learned single judge has took a notice that yes, petition is filed after almost 10 years, but therefore back wages has not been granted.
Yeah.
But whether after 10 years this relief can be granted, that is not dealt with. We'll examine it. When? Give a date.
Any date. Tomorrow also I am ready anytime.
I am ready, my lord.
You're ready.
Tomorrow.
You're ready. Not.
So matter will fix for hearing next
Okay.
week.
As the matter has already been admitted, list the matter for hearing. Give a date, not next week. Thereafter. Next week is not sure.
Okay, no issue.
Give a date. Not next week. Hereafter.
All right.
Prayer will be the same, my lord. Same prayer.
Want an adjournment?
Lordship,
Who is for respondent number 5?
I think it's a private respondent, man. I don't know.
But respondent number 5, some lawyer appears and seeks an adjournment. But till that, no wakalatnama has been filed. So we'll say that it will proceed ex parte.
Lordship, this matter was
5.
praying direction by this honorable court to the concerned authority to execute the work according to the DPR. So after filing of affidavit of government, our grievances has been addressed. So matter may be closed.
Close.
Yes.
Okay. It is submitted by the learned counsel for the petitioner. No life cause of action survives in the present public interest litigation. Accordingly, same may be closed. Full stop. In view of the such submission, the present PL stands closed.
May be obliged.
This matter is ready for hearing.
Yes, my lord, just yesterday I received the paper book, my lord. So I need to go through.
You have received a paper book. We
Yes,
are
ma'am.
fixing it for a hearing. Give a convenient date. Paper book is prepared. Everybody is represented.
Yes,
This
sir.
matter is ready as regards service record and paper book. Accordingly, list this matter for hearing on,
After 3 weeks, man.
list this matter for hearing after 3 weeks. Have you received the paper book?
Yes, madam.
Yes.
Yes, Lordship, that I have served the copy to the opposite party, but they have not filed.
What about respondent number 3? This is item number 5, isn't it?
Yes, Lordship, I have served respondent number 3.
Huh?
They have already received the copy also, Lordship.
Who
Respondent
is respondent number 3?
so yes, sir, Lordship.
You are for respondent number 3?
Yes, Lord.
Huh?
Okay.
This one, correct or message?
Yes.
Yes, Saikya, who is for respondent number 3?
3, madam. 4, 3 and 4, madam, I will be appearing, madam.
3 and 4.
Yes, madam.
Okay.
We need some time for filing.
Okay, though office note dated 7/11/2023 reflects that steps for service of notice upon respondent number 3 is not taken. However, Mr. R. Saikia, learned counsel, submits that he has instruction to appear on behalf of respondent number 3 and 4. And he prays for an adjournment to file affidavit in opposition. Accordingly, matter is ready as regards service. Full stop. Prayer for adjournment is allowed. List after 2 weeks.
3 weeks, madam.
Huh? 3 weeks. 3 weeks. Fast. Yes.
My lord will recall yesterday's suspension matters that have been fixed for tomorrow. There are 2 other matters, my lord.
Okay.
May I please, Your Lordship?
Yes.
I also beg to mention item number 18, Your Lordship.
Item number?
18.
Yes.
This matter may be listed after 15 days, Your Lordship. I need to file one application for the substitution of the respondent, Your Lordship.
Not yet filed.
Not yet have been filed.
Okay. The learned counsel for the petitioner prays for further
2 weeks. Yes.
2 weeks time to file the interlocutory application for implement. Full stop. Prayer is allowed.
Highly honored.
Lordship, I would like to mention item number 27. Lordship, may kindly take up this matter on 15th of this month, Your Lordship. I've taken the consent of the petitioner.
Item number?
27.
This matter is an urgency, my lord. It's question of dismissal.
Dismissal from service.
So,
Okay. Can it be the next year thereafter? Next week is not sure of we are not, the position of next week is not so clear.
but then on 20,
220?
20.
Okay. The learned counsel for the respondent state has prayed for an adjournment in this matter. However, the learned counsel for the petitioner has expressed urgency as the matter relates to the issue of dismissal of the petitioner from service. Full stop.
Otherwise, an attempt may be done on maybe on 15, if this is not.
No, we are speaking of 28. We are not clear about whether the dividend bench will be available in the next week or not. That's why we are not fixing. Okay.
Lordship.
So whether who will be here, we are fixing it on. I'm not putting the burden on others. If I am here, then if you can make a mention also. Okay, if I'm taking this mention. It is difficult to fix the burden upon others. on the next, on 28th. Yes.
Obliged, Lordship.
May it please your lordship, I would like to mention item number 7, maybe fixed after 2 weeks. I've taken concern of
Item number?
7.
Okay, what do you want?
This matter may be fixed for hearing after 2 weeks. I've taken consent from the respondent.
You are
side.
for the
I'm for the
petitioner.
petitioner.
Why this matter is for at the admission stage, okay. The learned counsel, on the prayer of the learned counsel for the petitioner, the matter stands adjourned and be listed on 28th, 20.
Your lordship, after 2 weeks, sir.
After 2 weeks.
Obliged.
May I please, Lordship?
Yes.
Lordship, on behalf of the Ahmad Lordship, I beg to mention item number 19, Lordship.
Item number?
19, 19, Lordship. May be listed tomorrow, Lordship.
You are for?
The Ahmad Lordship.
No, you are for.
Petitioner, Lordship.
Petitioner.
Lordship.
Why you want tomorrow?
Lordship, relevant matter will be listed tomorrow, and Lordship, leading counsel, he is from Guwahati, Lordship. He will come tomorrow, Lordship.
What is the other matter fixed tomorrow? Related matter?
Related matter, Lordship.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed tomorrow. This is regarding an appointment of Hindi professor. Yes, education, who is representing education? I think education department is there, or who is appearing? Where is the main writ petition that is disposed of?
Dispose of my lord.
The APSC took a stand that we have recommended. It's now up to you to appoint or not to appoint.
My lord.
So that will require, you will have to require to answer whoever appearing for the education department. Higher education, isn't it?
My lord.
Because APSC, they has washed their hands off.
Yes.
They said, we have recommended, we are a recommendatory authority, you are selected, and there is a specific direction to complete the process within a specific period.
My lord.
So you may be in difficulty.
My lord, we have filed one review petition against this, and one appeal is also pending against this order, my lord.
But any stay,
My lord.
any stay
No
in
stay,
the
my lord.
appeal,
No stay, my lord.
any review, stay in the
No,
review,
review is yet to be listed, my lord.
then
Review is yet to be listed because the main writ petition was disposed of by, heard and disposed of by Honorable Justice Surana, my lord. He is yet to come visit here, my lord.
no, it's not necessary nowadays.
Okay.
It's not necessary nowadays. It can go to some other judge also. Or you can take virtually. There is
Okay,
a
my lord.
provision.
My lord.
Even there is an order by the Honorable Chief Justice that even bail matters which are being rejected by a judge are being taken virtually if he's in outstation.
My lord.
So you take note of that.
My lord.
We are adjourning it, but this is the situation.
My lord.
You will have to clarify your position. Yes, tomorrow. Yes.
May I please, my lord? I beg
Yes.
to mention item number 28, it's supplementary. On behalf of Mr. U Bori, the counsel for the respondent.
Okay.
I've
When
taken the consent of the petitioner counsel.
you are for the respondent?
Yes,
Okay.
Uttam Bori,
When?
after 2 weeks.
On the prayer of the learned counsel for the respondents, list this matter after 2 weeks.
Highly obliged, my lord.
May I please, Your Lordship? Your Lordship, one more item, that is item number 6, Your Lordship. This is a contempt case, and we have instruction that the contemptor has partly complied with the order, and we need to get a full instruction from our client, Your Lordship. So this matter may be listed up 2 weeks.
The learned counsel for the petitioner submits that the order which is alleged to have been violated has partly been complied with, and accordingly he needs further instruction from his client and to file an affidavit, to file an additional affidavit bringing those compliance on record. Mr. Prayer is allowed, list after
2 weeks, Your Lordship.
2 weeks.
Highly obliged.
Lordship, I beg to mention item number 3. This matter may be kindly taken up after 3 weeks. I'm for respondent number 2.
You are for,
Respondent number 2.
what happened? There was a direction, anything survives in this petition?
Lordship, I have been instructed, so
You wait, let us see. What about, have you informed the other side?
yes.
Unnecessary dismissals are pending. There is no stay. Whether you have received the information, you are not aware.
No, Lordship.
Unnecessary dismissals are pending. We'll admit this. We'll admit this and fix it for hearing in its usual course. There is no stay. Whether you are aware that the appellate authority, second appellate authority's order was complied with. That much only. On the prayer of the learned counsel for the respondent, matter stands adjourned and be listed after 4 weeks. Yes.
Lordship, I'm for the appellate.
Huh?
I'm for the petitioner, Lordship.
You are for the appellant. What happened? Anything survives?
No, your Lordship.
On last 2 occasions, nobody represented you. Now, other thing is that there was a direction to provide certain information. Whether you have provided,
Guidelines we have provided, but
not the other thing.
yes, yeah. Item number 1 and 4 we haven't provided.
But so you have not complied with the appellate order.
No, your Lordship. That is why we have impugned that order. We
But
have
there is no
challenged.
stay.
Lordship,
Anyway, he wants an adjournment. What to do after 6 weeks?
obliged.
On the prayer of the respondent.
Lordship,
Yes.
item number 5. This may be taken up after 2 weeks.
We'll admit this departmental proceeding, and we'll ask the respondents to keep the records ready. We'll fix it for hearing. Admit this writ petition. You wait for some time. We'll pass this order. Item number 5 will take not much time. We'll admit it and fix it for hearing. And we'll ask the respondents to be ready with the records of the departmental proceeding. Okay? Wait for some time. Yes, next case.
My lord, I beg to mention one writ petition pending before this court. May be kindly taken up tomorrow.
What is the urgency?
Urgency, it has to be listed after 4 weeks. It's been 2 months. This case has been not listed.
What is the subject matter?
Cancellation of land allotment.
Cancellation of
Land allotment.
any stay?
No stay.
Okay.
So, right.
Your Lordship, I'd like to mention item number 29. On behalf of learned counsel T. Tang, due to some medical issues, he's currently out of station.
Okay, tell me whether you have informed the other side. Mr. Sethi, yeah?
I'm for the petitioner. This matter may be listed on 15.
2820.
I have-
Promotion.
I have already discussed with the respondent.
You have discussed with the respondent, but not with the court. Isn't it? Your convenient date is 15, court's convenient date is 28. Okay? Which will prevail? Okay, 28. As agreed to with the learned counsel.
Much obliged.
Yes. Yes, what is, tell us.
Where you, Lordship?
Now tell me the distance.
It's the 30 kilometer, Your Lordship.
Why you don't want to go to the other place?
Your Lordship, I have been.
And what is your right to continue in the same school?
Your Lordship, it is a mid-academic session. And moreover, Lordship, I am a contractual employee. I am drawing a salary of merely 20,000. Now again, I have been posted there last 5 months. I have arranged rented and all.
You belong to which place?
I belong to Darak Circle, but I am residing here at Itanagar.
What is the distance between your home and the school?
Home and school is, sir, it's Alo and it's around 250 kilometers.
Yes, why you want to transfer a contractual employee?
My lord, it is a routine transfer, my lord.
No, we understand routine transfer. He was appointed on which date?
27th, I was appointed on 15 May 2023.
23
15th May.
15 May 23. Two persons were posted as contractual in two places. Suddenly, what is the exigencies of service that you want to transfer him, a teacher?
No, your lordship,
They are contractual employees.
My lord, exigency came here, my lord. Administrative exigency came, my lord.
What is the exigency?
This,
you want to know that.
This private respondent, my lord. Private respondent, this Libby Bagra, my lord. She is having serious medical case, complications, my lord, for which her matter has been considered, my lord.
Okay, on her representation,
My lord, my lord. Yes, my lord.
What is happening to her? What is her disease? Anything? Are you having the records?
No, record is not with me, my lord. If required, my lord, I can bring, my lord.
We want to see the reason. Till then, maintain the status quo. Taking it up the day after tomorrow.
After tomorrow. Okay, my lord.
Okay.
My lordship,
we want to see the reason.
My lordship, actually, she is also a contractual teacher like me.
No, we understand. See,
yes.
Suppose a person is ill.
Yes.
Department want to consider her case. Can we stop it as a writ court?
My lord. Yes.
If it is a genuine case. If it is not a genuine case, so therefore we want to see the record. Till then, till Friday, you be there, let her be there, she is there, and we'll examine the record and pass an order.
However, your lordship, I have been transferred there at Alo for 1 year, your lordship. My contractual agreement, service agreement is only for 1 year. I have been specifically transferred at Alo, your lordship. Just she might be having medical complication, but in order to accommodate her, your lordship, means my right also has to be.
What is your right to be in the school? Tell us first.
Your lordship, I have been specifically appointed for that school, your lordship.
Where is the appointment?
This is appointment order is in 15.
You have his contract also, huh?
Yes.
Contract entered into between you and him.
Okay.
That is the present petition is filed SLE and order of transfer dated
27 October 2023.
27th
October 2023.
Where is that?
Page 24. Annex 3.
An order of transfer dated 27/10/2023 issued by the Deputy Director of School, Samagra Shiksha, Papumpare District, Itanagar, Arunachal Pradesh, whereby the petitioner, who is a contractual teacher and posted at
Government Secondary School, Pakam. GSS Pakam.
GSS Patang, has been Government Secondary School Pakam, PAKKM.
Yes.
Has been transferred to where? To
GSS Kamba.
GSS, kindly see page 17, huh? GHSS, Government Secondary School Khamba.
Yes.
Alo, full stop. Alo, full stop. The Learned Standing Council for the Education Department submits that the respondent number, Libby Bagra is respondent number 6. Respondent number 6 is having severe medical and health issues, and accordingly on her prayer and for her better treatment, the transfer order was issued. Full stop. The learned counsel for the petitioner submits that he has a right to continue in the present school as he was specifically, the contract in respect of his appointment was specific to the school in question. In view of such argument, let the learned standing counsel produce the record pertaining to the impugn order dated 27/10/2023, as well as produce a copy of the contract entered into contractual agreement executed between the petitioner and the state project director Samagra Shiksha Vide number 184-262 dated 17 May 2023. Since till next Friday, the impugn transfer order shall remain suspended.
Oblige.
We'll see, and if we know you can consider a representation, no problem on that. But his case is that he is specifically appointed. Let us see his contract. If he is having any right, we'll think over it, and if otherwise transfer, it's difficult. Yes,
Oblige.
next. We have not issued notice to the respondents. Just we'll see on the next.
May it please your lordship. My lord, may I draw your attention on page 11, my lord, the annexes 1.
Yes,
My lord,
this is item number 2, isn't it?
Yes, my lord, item number 2.
The present petitioners are the present petitioner is a the present petitioner is aggrieved by non-payment of assessed land compensation amount
And the rent.
and arrears of rent
Yes.
assessed by the Deputy Commissioner, West Kameng District, Bomdila, for use of the land belonging to the petitioner. Full stop. Issue a notice returnable after 4 weeks. Who accepts notice for whom? Mr. Kato.
Madam, I am for respondent number 124, madam.
Mr. Kato accepts the DSGI accepts notice on behalf of respondent numbers
1, 2, 4.
1, 2, 3, and 4. Mr. Kato.
I am for respondent number 5, lord.
Respondent number 5. Madam. You are for respondent number 6. And any other respondent?
No, madam.
No other, only 6 respondents.
Only 6 respondents.
Okay. As all the respondents are duly represented by their respective councils, no formal notice need be issued. However, extra copies of the petition be furnished to the learned councils. Full stop. Pendency of the writ petition shall not be a bar for payment of the payment of the land compensation as well as the rent if the petitioners are entitled for.
Obliged, lord.
Yes, anybody appears for respondent number 2? Yes, who is for respondent number 2?
We are for respondent number 1.
1. Who is for 2? Yes, what to do? Service report is not complete in respondent number 2. Will take a fresh steps or what?
Yes, we did pray for the final argument, however. Yes.
It's okay, Your Lordship. We can continue with the final arguments, Your Lordship. The respondent number 2 is also asked on university, you know?
You can appear, okay.
Yes, sir.
It is submitted by MS?
J. Jongriju.
Learned counsel submits that she can also appear for the respondent number 2.
Yes, sir.
Accordingly, the matter is ready as regards service. Affidavit filed.
Yes, sir, we have already filed the affidavit also. We have mentioned it in the order, last order, last
Okay.
to last order. Your Lordship.
She further submits that the affidavit on behalf of respondent number 1 has already been filed.
Yes, Your Lordship.
And the same set
Same-
cover the stand of the respondent number 2.
Yes,
Full
Your
stop. In that view of the matter is ready as regards service and pleading. Accordingly, please this matter for admission on
Any short date, Your Lordship.
any short date.
If he is ready, we can argue today also, Your Lordship.
Otherwise, we can.
Yes, that's what I'm saying. If you are ready, we can argue today.
Yes.
Your Lordship, we are ready for the final argument. However, if the Lordship wants to fix another date, then.
Are you ready?
The December.
Today we might have a problem because we are, I think it depends upon Mr. Panging. Will you start it?
That was the understanding.
We'll start it. So today other matters may be difficult. We'll take up your matter after finishing the list. No? And because I want to finish it if possible by this weekend.
It would be difficult. I understand the London Senior Council, Mr. Mohdar is available only on 15th.
Only on 15th.
If
I was telling the London AG also last week.
Then what is the meaning 15? Then again you take the file to Guwahati, and moment you reach Guwahati, is it possible anything? Taking 80 meters.
I inquired yesterday, that is what they have told me, and they are not here.
Your Lordship.
I told in Delhi.
If I may, Your Lordship.
No, we are talking about something different. That's why we thought that. Then see, you see the situation. You have, because the state is having urgency.
That is no issue.
Public service.
State is having urgency. So we thought that we'll start the hearing today. And if possible, today is Wednesday, Thursday, Friday, maximum Monday.
Yes.
We'll
Not that long a matter.
No, you never know. We can finish it off. But he says that learned counsel, Mr. Mojumdar, will be available only on 15th.
I think that part, that part, Advocate General will take care because he has gone down to Guwahati.
No, suppose on 15th, Mojumdar is available. I'll have to leave on 17th. And I'll have to take the CAB to Guwahati. And moment you take the CAB to Guwahati, let me be frank, after deciding 80 meters per day, you have your own urgency. Better to fix it.
He appears on behalf of.
Yes.
Yes.
When is he available?
So he's available on 15 months.
But AG has expressed serious urgency.
Yes, Lord.
But if it is 15th,
Yes.
he will come on 15th.
Yes.
15th is a Thursday.
Wednesday.
Wednesday. It should be difficult because ultimately we'll have to decide something. Na? Whether it will take a short or long, it's not an issue. Issue is if it is 15, whether under 317 this power can be exercised or not exercised. What is that interpretation will be required. It may take short time, but I'll have to deliver a judgment interpreting those provisions, articles of the Constitution.
Otherwise, the London Senior can have a chat with the London AG.
No, AG is no problem. AG is coming.
He's coming today, my lord.
He's coming to the hill.
Because of the urgency.
Tomorrow. But if Mojumdar is on 15th,
That is the thing. That is something that.
and nobody is having any enjoyment, there is a stay. Your clients are also not having the appointment.
Yes.
Where is Mr. Mojumdar?
So due to personal difficulties, he is not able to come for
I have talked with the assistant officer. I told him in Delhi right now. In proposing. I called him yesterday.
Okay, let the matter be called for. Okay, on 28th. We'll hear this matter on 28th.
On
20.
28.
Delhi weather condition is very bad.
20.
20.
Okay.
20 of which month, Your Lordship?
This month.
This month, okay.
This month.
This month, all right.
Okay.
Oblige, Your Lordship.
This matter, and therefore, accordingly, matter be listed in the admission column on 28.
Highly obliged, Your Lordship.
Obliged.
The present writ petition is filed assailing an order dated 25/2/2021, whereby the petitioner was inflicted the penalty of reduction to a lower time scale of pay after a departmental proceeding and subsequent orders of appeal and revision filed by the competent authority. Full stop. The matter is ready as regards pleadings. Full stop. Accordingly, admit this matter for hearing and list it for hearing when? Give a date. After 2 weeks. After 3 weeks. The learned departmental council shall be ready with the records of the departmental proceeding on the date of hearing. You have the records, you will see. Issue rule will be one. Issue rule. Returnable forfeit. But returnable after 3 weeks. As parties are duly represented, no formal. Item number? Yes.
This is very small matter, bill pending, regarding bill pending. The affidavit of the department has already been filed.
Petition on behalf of respondent number 566 filed.
Yes.
Pleading is complete.
Yes.
Do you want to file any reply?
No. I'm petitioner.
You are petitioner?
Yes.
Okay, all affidavits are filed?
Yes.
You do not want to file any rejoinder?
No.
Okay. What is the issue?
This issue was bill there's petitioner was claiming some bill amount from
You
the
have a
department.
difficult case.
No, my lord, it is already being admitted that they are ready for they admitted the claims by the department. So it can be.
Where is that admission? Department has taken a stand that there was a direction, election officer to take a stand that there was direction not to proceed with the work.
My lord,
Just a minute. Okay. That is their stand in the affidavit, is not it? And the engineer takes a stand that yes, he has executed the work, but
more particular para 6, my lord.
But there was a stand somewhere that it was order was issued without the budgetary provision.
No, that was claim of the chief election.
No.
But the concerned department who has executed the work, they are the respondent of 5, 6, and 7. And others are they are the required department, that is election commission. And one who educated, that is the concerned department, the engineering department, who has actually educated the work.
What is the affidavit of PWD, Public Works Department?
My lord, affidavit of respondent 5, 6, and 7.
See, how can a report direct? You might have a case of a compensation a decree, everything. See, come to page 3 of the affidavit of the PWD. Public Works Department. Paragraph 6.
Page number 3, no, my lord.
Page 3, paragraph 6.
My lord, I got it.
Kindly see, additional work of, for the earlier work, 6,40,000 paid. Additional work of CO cell for EVM and VPAT was proposed and estimate submitted for sanction. Work was carried out in anticipation of sanction and placement of fund. How can a read code direct, and whereas the election authority has taken a specific stand saying that we have asked not to continue with this work? You are in a read court. In a read court, we can pass a direction for awarding the making the payment only when, in view of that judgment, full bench judgment, only when the head of the authority admits, not even executive engineer, the secretary of the department is to admit that yes, you have executed the work, we have money, we cannot pass an order. Therefore, I said, will you not file any reply? You said no.
My lord, I have been awarded work order. On the basis of work order, I have executed the work.
Understand, you are in a read court. If you can prove that a work order has been issued, you have executed actual work, these are the bills, you may be entitled in a civil court. Not only the amount, with interest and compensation. But in a contractual matter like this, what is the judgment, Mr. Pangi? The full bench judgment? Muslim Mondal. Tamser Ali.
But in one side, say my right, if they have not awarded the work orders, I would have not been educated.
Can we decide all these disputed issue in a writ petition?
No, my lord.
I can answer right now, quoting this affidavit, quoting all this.
My lord, why I'm submitting this, that my right, because it is the authority who has issued the work order. And on the basis of the work order, I have executed the work. And if they have not asked me to execute
Now
the
they
work,
have taken a different stand.
so it is the responsibility, liability go to the department and not upon me. I have committed no wrongs because I have done accordingly as per the direction instruction given by the authority.
Upon us, but so far relating to the contractual matter, there are certain judgments and limitations of a refereed court. In view of their affidavit, I have no option but to dismiss your writ petition and relegate you to a civil court.
My lord,
saying that these are the disputed questions. However, the civil court will not influence by any of the observations made because these are disputed by the respondents in view of the judgment in Tamser Ali. This court cannot pass an order for payment of the bills. That's why I asked at the beginning that whether you would like to file a reply to the affidavit filed by them. You said no.
Because what I'm of opinion is that because since the authority has been already convinced that they have the duty to give, so that is why I was concerned. Anyway, my lord, then I may be allowed to file reply.
Okay.
In the sole date,
learned counsel for the petitioner submits that he may be permitted some time to file a reply affidavit to the affidavit in opposition filed by the state respondents. Your bad luck. Without sanction, you have been asked to execute the work. And they are saying that in anticipation, one party says that, and others said no, even we have asked them, asked the executive engineer not to do this job. But now, in this dispute, how can a read court say, no, you'll have to pay the money? You have a very good case for not only the amount, if you can prove it through documentations to the bills and all, but also we are having a very good case for compensation.
My lord,
Huge compensation, but which
Section 70 of Contract Act also says that
Ah.
after being used, you cannot deny the payment.
but that cannot be
They are
decided by
using.
that cannot be decided by a writ court. It will take 10 minutes, 5 minutes to dismiss your petition by this court.
Okay, my lord, let me allow to file
Okay,
reply. Okay, most obliged.
For content number 2, my lord.
Hmm.
I am appearing for content number 2, my lord. My lord, unless the matter with WPC, my lord. The main case, my lord. WPC 280/2022, my lord.
Where is the order? Now have they stopped the work?
Yes,
No, yes,
yes, my lord.
Huh?
Yes.
So I think better we hear the writ petition.
with petition along with IA and this contempt laws,
Okay,
club together.
okay. The
My lord, matter may be fixed next week, my lord. Next week. Matter may be listed for next week, my lord. In any day.
your basic challenge is the deputy commissioner's order.
Yes, yes, sir.
Whereby deputy commissioner has decided you
Right and title.
right
Yes.
title interest. Now that order was there.
Is there also.
Even after that order,
They have instructed,
continued with
yes,
some work.
continue the construction.
Now if
activities.
file a contempt,
Yes, yes.
then warrant issued, then they stop the
Yes, sir.
work. So we'll hear whether deputy commissioner is having power. That much only.
Yes, sir.
It is submitted that the status quo order passed in WPC 280/AP/2022 dated
7/2, dated 7/2/23 laws.
7/2/2023 is being maintained by the parties. Though initially there was violation of such order and the present contempt case was filed. Accordingly, the learned counsel for the parties have submitted that the writ petition may be taken up for disposal on the next date fixed. Pleadings are complete.
Yes, madam.
As the affidavits have been filed in the aforesaid writ petition being WPC number
280 laws. 280.
280.
Public
WPC number
280.
280
2023.
No, not
22 laws.
WPC number matter ki kolo 280 AP 2020
Yes.
2022. Prayer is allowed. List WPC number 2020 WPC 280 AP 2022 along with IA.
IA laws is 28 laws.
IA will automatically will be there 2022 on
16, my lord. 16, either 15.
on 17th.
17.
Okay,
Yes, sir.
on 17th.
17. 17. Okay.
My lordship.
On 17th of November 2023 along with this contempt petition.
My lordship,
Status quo order was passed in IA 20.
Status quo order passed in IA
20.
20 of
28 of 23. Lordship.
28 of 23 dated. The
Dated-
date is correct?
Yes, sir, that is correct.
To do something, every time you have to come, no? End of the list. Please this matter before any other bench without me.
Lordship.
Yes, my lord, matter pertains to stepping.
You said that on earlier occasion that similar matter is pending before the, still pending.
Still pending. The man is retired in the meantime.
Okay, the Mr. Panging, learned counsel for the petitioner, submits that the issue involved in this present writ petition is pending for determination before the Honorable Apex Court in Civil Appeal number 2016 of 2020. And same has not yet been decided. Accordingly, the matter stands adjourned sine die with a permission to the petitioner to make a mention as and when the Honorable Apex Court decides the issue. List accordingly.
This matter, government has come affidavit, the private respondent, taken state.
Yes, government, what is this affidavit? May be, might be, huh? Kindly come to paragraph 4, page 4 of your affidavit. Likely, paragraph 7. We do not want an affidavit from a secretary like officer, this kind of affidavit. Kindly read paragraph 7.
Lordship, I have imported, we have also sought clarification, but
So is it can it be a stand? And it is likely that former Anganwadi worker used while mentioning the petitioner. This is very likely a case of clerical slip up made by CDPO concerned. Cannot he ask the CDPO? Actually, what happened? Can it be a stand of a government? Likely, might be.
Lordship, actually, CDPO should have also been made a party here, Lordship.
No, CDPO not made a party. You are the controlling officer of CDPO. Isn't it?
Lordship.
So you have instruction and file a proper affidavit. Actually, what happened?
Lordship, reported also, we have sought clarification that.
See, can that be a stand? You take a specific stand that she was not in service. These are the records. Therefore, there was an advertisement. Other person was appointed. Take a specific stand so that he can respond to it. Might be likely. Though an affidavit in opposition has been filed by the respondent number 2, no specific stand has been taken regarding the allegation of the petitioner that though she has been working as Anganwadi worker, she has not been paid her salaries, and in her place, respondent number 4 has been appointed behind her back. The affidavit is silent whether and how the petitioner was appointed, when and how the petitioner and the respondent number 4 were appointed. And if the petitioner was duly appointed, and continue to serve while her salary has not been paid, and if she has been terminated, in what manner she has been terminated, that is also not discernible from the record. From the affidavit, it is seen that the entire responsibility is relegated to the CDPO concerned. However, how the CDPO has conducted how the CDPO has acted in the manner is not discernible from such affidavit. The affidavit, respondent number 2 being the what is his is a program officer of the Director of Women and Child Development, Itanagar, in the considered opinion of this court, is not the proper person to file the present. Who is the respondent number 2? Whom you made the respondent number 2? Not a proper person to file the affidavit on behalf of the respondent number 2. Therefore, it is directed that the respondent number 1 shall file an affidavit taking a specific stand regarding allegation of the petitioners by way of an file an affidavit taking a specific stance against the allegation made by the petitioner in the present writ petition. List this matter after 3 weeks. It cannot be. You have an inquiry how it was done. What is there is no alternative. In the act. No. Why this matter is listed today?
Lordship, in fact, I have filed one additional affidavit stating that the respondents they have declined to accept the dusty service, Lordship.
Okay. Respondent number 3. What is that affidavit?
Lordship.
Just a minute. You have served it?
Lordship, they have declined, Lordship. In fact, we have approached them, but they have declined.
Who is respondent number 3?
Lordship, respondent number 3. Lame Pusang, Lordship.
The petitioner has filed an affidavit so far relating to service of notice through dusty upon respondent number 3. And it is specifically stated in which paragraph?
Paragraph
2,
Lordship.
At paragraph 2.
Page 3, Lordship.
Specifically stated that the writ petitioner made the private respondent personally on 25/9/2023. However, the respondent number 3 refused to accept the notice in view of such stand in the on affidavit, the notice in respect of respondent number 3 is accepted. Accordingly, matter is ready as regards service. List this matter in the admission column after 2 weeks. Same in 16 also.
16 also.
You also file affidavit.
Lordship.
Same person.
Not same person.
But other person. But you have taken the same stand. Date
Same
is
stand.
25/9.
Lordship.
Same date.
Same.
Okay. 16 same order. Respondent number is also same.
Respondent number, Lordship, they are different, I think, Lordship.
Tell us the respondent number and the date.
3, Lordship. Respondent
3
number.
here in earlier also 3.
Lordship.
And date the same.
No, name is different.
What is the date when you?
Name is different, Lordship. Tame Pupor, Lordship.
Not name, date.
Date, Lordship.
When he refused. 16.
There are, Lordship, several dates, Lordship.
No, you have said that in the earlier petition you said that on such several dates you attempted, but finally date of refusal.
Date of refusal, Lordship, on several 9/9/2022, 11/10/2015, 12/2022.
You refuse to
Paragraph 4, Lordship.
accept the notice.
Paragraph 4.
It is specifically stated at paragraph 4 that the petitioner on 9/9/2022, 11/10/2022, 15/12/2022, and 5/6/2023 attempted to serve the notice upon the respondent number 3. However, the respondent number 3 refused to accept such notice in view of the truth. Yes. Yes. Rejoinder. Will you file or not file?
Oh, my lord, private respondents are yet to file their affidavit.
Item 17. Rejoinder not filed.
Yes, ma'am.
Will you file it or not file it?
Oh, my lord, I am from petitioner.
Who will file rejoinder affidavit? You will file rejoinder affidavit.
No, your lordship, petitioner.
Isn't it?
Yeah, petitioner will file. Your
Petitioner, you will have to file the rejoinder. They have filed affidavit in
Yes,
opposition.
lordship, we
You
have
will have to
already
file
filed.
reply. Will you file it or not file it? Take a call.
My lord, private respondents are yet to file their reply.
Is it?
Yes, ma'am. Counter affidavit.
Here it says that respondent number 4 and 5 has already filed affidavit in opposition.
So,
You took time to file rejoinder. Will you file it?
rejoinder. No, my lord.
See, there are affidavit in opposition respondent number 4 and 5. Affidavit in opposition of respondent number 2 and 3. So one will cover 2 and 3. You wanted to file a reply. Will you file it or not file it?
That, my lord, I have not been instructed. My
Who will instruct you?
senior, my lord. I am appearing on behalf.
Oh, junior instructs seniors. Senior will not instruct a junior.
My lord,
You'll have to read the file. You'll have to read the record. Seniors, juniors are there to assist seniors and to give instructions. Sir, you'll have to argue this. This matter is listed for this. Senior will not instruct you. So what to do? Take my instruction then. The learned counsel for the petitioner prays for and is granted 3 weeks time to file a reply affidavit to the affidavit in opposition filed by the state respondents. Okay? Now you instruct inform your senior that we have been granted time.
Yes, your lordship.
I don't know what What to do?
Yeah, Your Honor. Your Honor, I'm appearing on behalf of Titaum for the petition, Your Honor. The service report of the respondent is still awaited, Your Honor.
What to do? Await.
We
Okay.
can
Await service report in respect of the sole respondent and list this matter after 3 weeks with an updated service report.
Pleasure.
With an updated note.
My lord, we took a step, but it is not reflected in the court. Therefore, my lord, we may be allowed to take fresh step.
You have taken steps?
Yes, my lord. But it is not in record.
It is submitted by the learner. When have you taken steps? When have you taken steps?
Or this after last hearing, my lord.
Huh?
After last hearing, my lord. On my lord.
Till last state.
It was around 15th of my lord,
15th of
July, my lord.
15th of July.
Yes.
Though office note dated 8/9/2023 and 7/11/2023 reflects that steps for service of notice upon sole respondent has not been taken by the petitioner, the learned counsel for the petitioner submits that he has taken steps for issuation notice upon the sole respondents in the month of July 2023. However, he further prays that he may be allowed to take fresh steps once again. First, the prayer is allowed. Steps be taken within a period of 5 days from today.
Much
That
obliged.
might have been misplaced.
Yes.
You take fresh steps.
Yes, much obliged.
None appears for the petitioner on call. Office note dated 7/11/2023 reflects that service report in respect of respondent number 1 and 2 are still awaited. Full stop. Await for service report and list this matter after 3 weeks with an updated office note. Same order in respect of respondent number 7 and 9.
My lord.
We'll await for service report 7 and 9.
Yes, my lord. But there is something which I want to express before the court.
Yes. Keep the file.
Last on 13th of the last month, respondent number 9 has called the respondent number 7 and the petitioner in order to comply the disorder.
Okay.
And on that, respondent number 7 has not appeared before the deputy commissioner as per the order, of this. And see, respondent number 7 has sent a representative major. It is respondent 7 is a colonel. Representative was major. He was saying that they are not the proper authority to comply this order. And it is respondent number 5. They're saying that it is the respondent number 5 who is
appearing for respondent number 5?
My lord, when notice was issued by this honorable court, this honorable court saying that since just this order has to be complied, so those who are necessary
Court
then
says that you have served notice upon 7 and 9 only.
yes.
So you now serve upon respondent number 5. Tell all these facts.
Yes.
And file an impleadment petition or file an application that notice should be issued to them.
Okay.
Okay. The learned counsel for the petitioner submits that he has. Have you intimated the respondent number 5 now?
Yes. Already have intimated.
Okay. Submits that he has already intimated.
Serve the
In
copy
this
of.
case-
Serve the copy
In
of.
this case, notice was issued to respondent number 7 and 9 only by this court under its order dated 24/8/2023 for the reason that the copy of the order alleged to have been violated was furnished only upon respondent number 7 and 9. Full stop. Today, the learned counsel for the petitioner submits that he has already furnished a copy of the order before the respondent number 5, and the respondent number 5 has not complied the said order till date. Full stop. Accordingly, he prays that he may be allowed to file an additional affidavit to bring the aforesaid fact on record. Full stop. He may be a prayer is allowed. List this matter after 2 weeks. In the meantime, the affidavit may be filed if so advised. then only we can issue notice. You will see it whether you have served, whether complied with them.
Yes, yes.
So far relating to respondent number 7 and 9, await service report and await service report. Now item number 24 and 25.
And the leading counsel for the applicant is not here. Because,
IA,
yes, my lord.
modification, transfer order.
Transfer matter. They file IA for vacation.
IA for vacation.
Yes, they file.
You want time?
Yes,
Oh, you have filed IA and you want time, okay. The learned counsel for the applicant. Where is the Mr. Taragan? He is having some problem.
yes, he has asked me to fix it on 14th of this month.
14.
Yeah,
14.
on Tuesday.
14.
Yes, next Tuesday.
No problem.
Okay.
14th, if it's on 13, it will be well better.
13 is a holiday, I think. Oh, no, 13 is not holiday.
Monday.
Not holiday. Okay, 13. Okay. Learned counsel for the applicant prays that matter may be adjourned and be fixed on 13th of November 2023. Prayer is allowed. List accordingly.
My lord, interim is there.
Interim order pass earlier shall continue till then. Will be prepared, will decide the repetition itself on that day.
Yes.
My lord,
Yes.
during the pendency of the petition, my lord, writ petition, the transfer order has been modified and the petitioner is retained eternal therefore, my
So
lord.
you have no grievance.
Matter
Huh?
became infractions.
In
The
practice, my lord.
petitioner submits that his grievances has already been redressed by the state authorities. Accordingly, nothing survives to be adjudicated in the present writ petition. In view of such submission, matter stands closed, being infructuous. Interim order, if any, stands vacated.
Much obliged.
Yes. What have you have a talk with Mr. Chaudhuri?
Yes,
Yes, if he is coming on 15th.
otherwise, my lord,
My lord, we are in such a position. my
Now
lord.
we understand. That's why we have fixed
Delay
it.
will not serve purpose either to the petitioner or to the government. my lord.
Yes.
Because
Either way, it should be decided.
they keep on saying that, but it is their own doing. They appointed us, but they succumbed to something and they did that.
no, that is the reason, that is different issue. Appointed matter whether that
Now tell us how to proceed with this matter.
now as Lord
I
Advocate
have to
proposed, my
proceed
lord,
this
let Mr. D.K. Parkin start, my lord. He'll address you lord tomorrow. Then so far Mr. Dilip Manjujan is concerned, my lord. If he could make it on 13 or 14, it's
He
very well
cannot come before 15th.
That is the
before 15.
Otherwise, my lord.
Or
they'll
else,
submit,
my
my
lord.
lord.
Yes.
Or
Let
else
the
he-
matter be listed tomorrow and before the Lord Advocate General, then matter.
Okay.
That can be also
Then
done.
15.
Because otherwise,
Then
I
we will
argue,
hear it tomorrow. Otherwise, Advocate General is coming tomorrow.
I will press my
Okay.
argument and ultimately if
List
something
this
happens.
matter, list this matters tomorrow. Okay, that is a better proposition,
Yes.
I think.
Ultimately, if Mr. Mojumdar does not turn up, then my lord, the whole exercise becomes.
But
We would have liked it.
But you said that there are some written arguments and all.
We submitted on last occasion, my lord, I don't know.
Can you just go through the
Yes,
record?
I will.
If you can find it out, judgments are there, then I'll have an idea of the matter. If those are there, I just separate it from both the. Next. So we'll hear it tomorrow. We'll start the hearing tomorrow.
The citation, then it should be like Supreme Court pressure, in compilation.
I could not find the use of it. Are there, but what about your written argument? Not there. Just you look into it. If not there, please, that's why I'm saying, you have it, I think you'll have in your computers and, yes, yes. If you are having, you just put it inside so that I can have an idea of what is what. And if there, if something is there by the state, that can also. Anything was submitted by. Okay, you inform the Advocate General regarding this issue, so that he can come. He might have in his residence. Inform him. Yes, written. That's why I said. Yes.
May I please, Lordship?
Yes.
Lordship, I'm for the petitioner. My senior is from the Delhi based.
He's there.
Please, madam. Please, madam.
Yes, what are these matters? What are these matters?
My lord, may I explain? May I just give a brief background, my lord?
Yes.
My lord, there was a notice issued to the petitioners, who are basically 17 government employees from various departments of the government, state government. Now, they were issued notice back in 2021 for eviction of the government houses, because there was a project to be constructed at the same place that their quarters were there. Now, my lord, they challenged it by way of a writ petition, which was ruled in their favor. But the state appealed via writ appeal, my lord, and the writ appeal was decided against the petitioners. They were asked to evict the houses. My lord, this order was challenged before the Honorable Supreme Court, and the Supreme Court stayed the order. And finally, in August, on 7th of August, the Supreme Court disposed of the matter, saying that you evict the houses on or before 31st of October, which was 1 week ago. But my lord, during the pendency before the Honorable Supreme Court, a particular order of the government came into the notice of the petitioners, my lord. This particular order, which is Annexure P13, my lord, what they have done is, there is another batch of government employees who are 7 in number. They were also similarly situated as the petitioners. They were also asked to vacate their houses, but they were given alternate private rented accommodations. What they said was, you will give you rented accommodations. We'll bear the rent for 1 year. In 1 year, we'll try to finish off the project. And once the project is done, we'll give you back the quarters. Now, my lord, the petitioners now again have come before this Honorable Court, not trying to bypass the Supreme Court or not challenging the Supreme Court's order, just seeking parity with the other batch of petitioners, the other batch of government employees, my lord. Now, my lord, what happened on the last date? My lord, the Honorable Court heard the matter finally, and the order was reserved. So, as per my understanding, the final order was to be passed. But then, my lord, an order came which said that the state has to file an affidavit in opposition, and then the matter may be decided finally. Now, my lord, the only urgency is 31st of October, which was the deadline given by the Supreme Court. It has already passed. But because of the vacation and everything, the matter could not be taken up finally. The last order, my lord.
Last order is 11/10.
Please, my lord. And then the court went on vacation from 16th, I suppose, my lord, from 16th till 6th. So the matter could not be heard. On the last occasion also, the matter was reserved, my lord, with great respect to the court. But then this order came to be passed.
Yes, affidavit is filed. What to do? There is a judicial order.
Please, my lord.
There is a specific judicial order.
Please, my lord, I understand. I bow down to
the
that.
Respondents shall file their affidavit if so advised invariably on or before the next date.
My lord, that was told to them on 3rd October also, but they've chosen not to file, my lord.
See, now your grievance is that you should also be given
Private rented accommodation, my lord. The
private
rent for
rented-
which has to be borne by the government for 1 year. My lord, may just have just one annexure. Page 113 is the annexure P13, my lord.
Yes, why have you discriminated?
Page 116. I'm sorry, page 116.
Page number?
116, 116, my lord. Annexure P13. These are the 7 government employees similarly situated, similar posts, similar departments of the state government. They have been given alternate rented accommodation. Whereas to us, they are saying you take HRA or you go to some other place. Will not give you private rented accommodation. This is the grievance, my lord. Also, my lord, one more thing. The project that was to be constructed in place of the quarters that we are living in, I am told that this project has now been shifted to someplace else, my lord. I do not have any documents in support of that, but the government may answer that, my lord. The state may answer that. Has the project been shifted to some other place, or the project is still to be done, is still to be constructed at the place where we are living?
Why are you taking this kind of stand? Yesterday, we have dismissed the petition.
Yes.
I think we have dismissed the petition.
Yes.
Now, the question is, suppose in those cases, you have given some alternate accommodation. They were aggrieved that we are not happy with the alternate accommodation. We said that give him HRA.
Yes.
Now here his case is that you cannot, what is the basis of giving some persons rented accommodation, some not, no accommodation?
Yes.
So you just file a specific affidavit, what is the criteria followed regarding granting rented accommodation for 1 year. We can decide whether your criteria can be judicially reviewed or whether it is valid in the touchstone of Article 14.
Please, my lord. I'm grateful to that. My lord, also this query, my lord, that I raised, my lord, whether the project for which they are vacating us is still to be constructed there, or has it moved to some
No,
places?
that may not be for the time being, because suppose they have not, for a quarter, you are not having any right.
Please, my lord. Please, I bow down. Yes.
You don't have any right as such for a quarter. First. Second thing is that you are having the HRA. Because if we take a call that everybody is to be given a quarter, it cannot be vested and concluded. Right?
I agree.
So if that be so, the limited case is that whether the similarly situated person are discriminated in a similar situation.
I bow down to that. But my only concern, please, my lord.
That's all. So they will clarify only on that point whether this accommodation, what is the basis of this accommodation and the criteria of the accommodation, and we'll test it.
My lord, I was asked to bring written instruction in previous hearings, my lord. So last time, I also thought this matter has been disposed, but actually, because I brought the written instruction, and the housing department says, my lord, because this specific allotment, the rented house which has been given to the allottees in this case is under smart city project. A smart city project, they might have some additional funds to do that one. As a department of housing,
that is not the issue. Issue is,
yes,
suppose these people A, B, C, D,
yes,
they say we are equally situated.
Yes,
all are suppose at grade 3.
Yes.
Now they are in a specific area in some quarters. They were asked to vacate.
Yes.
Okay, they cannot assail it. We have already dismissed some of the petitions. Either in some cases you have given some people alternative accommodation in some quarters. They say we are not happy with it. We said, okay, if you are not happy, take HRA and go home.
Yes.
Take your own accommodation. We have no problem. In this case, he says that these people are 7 people are specially treated, though we are similarly situated. You might have many reasons. You might have some criteria.
Yes.
There may not be availability of more than 7 rented premises. You might have that reason. But even if suppose there are 10 rented accommodations available, you can adjust 10 people. Now, why this A, B, C, D, E? Why not F, G, H?
Exactly.
If you can show us that no, this is the criteria we followed, and therefore this, in view of this criteria, these people fit into this criteria, these people will not fit into the criteria, we will not interfere with it if it is reasonable. That's all.
The classification has to be qua the employees
Yes,
and not the
of
government
course.
departments, my lord.
No, of
They cannot say we are a different department. They have
Okay.
to please.
Okay. The basic salience heard Mr. S. Roy virtually, also Mr. Swenso, learned counsel for the housing department. The petitioners' basic grievance is that though they had vacated their quarters in view of proposed construction of the new quarters in place in the place where their quarters were situated.
My lord, I'm sorry, we are yet to vacate, my lord.
You're yet to vacate.
Yet to vacate, my lord. Because of the ongoing vacations, we are yet to vacate.
Now, what is your last date of vacation?
31st October.
My lord, it was 31st of October.
Then how can we give you relief?
No, my lord, that is why I'm just requesting if it may be heard very, very quickly, my lord, very soon, in a couple of days, my lord. Whatever then, my lord.
We cannot interfere.
No, but I bow down to that. We are ready to
because
vacate.
who will pay the escalation? For you, this project is stalled. How can they complete it within 1 year?
My lord, I understand. That is why
we have given a month's time day before yesterday.
My lord, that is why my request is that it may be heard as soon as tomorrow or day after, my lord, or next week, when as per the court's convenience.
Okay. Basic grievance is that basic grievance is that the similarly situated person, that two of the present petitioners were allowed rented accommodation for 1 year rent of which shall be provided by the employer department by an order dated 27th of April 2023. It is the grievance of the petitioner.
No, that's not correct, Malak. It would be borne by Smart City Development Corporation.
Just his submission.
Okay.
27th of April 2023. Full stop. The grievance of the petitioner is that while granting some accommodation, the petitioners have been ignored and pick and choose method has been taken while granting such accommodation. Full stop. Accordingly, such order has been challenged, being violative of the Article 14 of the Constitution of India. Full stop. This court, by order dated 11/10/2023, directed the state respondents to file an affidavit in opposition. Full stop. Same is not filed, and the learned counsel for the respondent pressed for some time. Full stop. The learned counsel for the respondent shall either file the affidavit or bring instruction specifically what criteria was followed in accommodating the rented accommodation to the aforesaid 7 persons. Yes. Aforesaid 7 persons and aforesaid 7 persons. Full stop. On the basis of such affidavit, this court will further proceed in this matter. Yes. Okay.
Yes.
We file that. Why and what you are saying, smart city and all this all incorporated.
Yes,
single, because other things are undisputed.
Yes,
that they are government employees, that they have been given quarter, now they have been asked to be vacated. All these are no dispute. Only dispute is that they also want rented
They
accommodation.
were given, here they were given alternate accommodation also, my lord.
Okay, you bring on record that.
Yes.
Okay,
All right.
just give that.
Yes, yes.
List this matter on.
My lord, may I have a particular date since he will be joining in virtual mode? Particular date?
My lord,
You
any
give a
date, my lord, as soon as your lordship thinks fit, man.
November.
Order 17 fix facility. This is 17 post kora, huh? 17 no body. When? On
21st November, my lord.
21st November?
Yes.
Okay, 21st of November.
Yes.
The learned counsel is permitted to make a request for a virtual hearing.
Please, obliged. I'm grateful, man.
All right.